Have you just closed a deal? Great. While you await the final draft and execution of the main contract, you and the parties involved can sign a deal memo. In this video, we will look at what a deal memo is, whether a deal memo is enforceable, the benefits of signing a deal memo, and some of the key things that should be included in a deal memo. Let us begin. A deal memorandum, also known as a deal memo, is a document that summarizes the main points of a proposed contract. It is not the final contract between the parties but serves as a placeholder until the execution of the final contract. Is a deal memo enforceable? The enforceability of a deal memo depends largely on 5 main points. Firstly, the intention of the parties to the deal memo. Did both parties convey an express intention to be bound by the terms contained in the deal memo? Or did they merely express a desire to enter into a future contract? If the parties intended to be bound by the terms of the deal memo, then such deal memo may be enforceable. But, if the parties merely expressed a desire to enter into a legal relationship in the future, then such deal memo may not be enforceable. Nevertheless, there may be some exceptions depending on the circumstances of the case. Secondly, whether a deal memo is enforceable or not would depend on whether an express offer was made by one party and clearly accepted by the other party. This is referred to as offer and acceptance in law. If an offer was made and accepted, then such deal memo may be enforceable. However, if the deal memo merely shows the desire or intention of either party to make a future offer which may or may not be accepted by the other party, then such deal memo may not be enforceable. Thirdly, does the deal memo show that either party has given something of value in exchange for goods or services or an expectation of the enforcement of the contract? If this is the case, then such deal memo may be enforceable. Fourthly, are the terms of the contract legal? This is important because the courts of law cannot enforce an illegality or illicit transactions. Lastly, do the parties to the contract have the legal capacity to enter into a contract? This is simply whether the parties are within legal age, or whether either of the parties have a mental or legal disability that could prevent them from entering into a valid contract. The absence of legal capacity can render the deal memo unenforceable. This brings us to the benefits of signing a deal memo. There are several benefits of signing a deal memo. One of such benefit is that a deal memo reduces conflicts and misunderstandings between parties. Since a deal memo clearly shows the key terms of the deal, the parties can revert to it for clarifications in the event of any mistake or misrepresentation in the final draft of the contract. This can prevent either party from unilaterally changing the terms of the contract or deviating from agreed terms. A second benefit of signing a deal memo is that it provides a framework which would stipulate the essential terms to be included in the final contract. A third benefit is that a deal memo can provide leverage for the parties by ensuring exclusivity. An exclusivity clause can be included in the deal memo which would prevent either party from negotiating with other third parties. However, this is subject to the interests of the parties. Now, let us look at the key things to include in a deal memo. Basically, a deal memo should summarize the following. Number 1. A brief description of the deal. Number 2. Key terms of the deal such as payment terms, delivery deadlines, exclusivity, warranties, confidentiality, contract duration and termination, and governing law. Number 4. Reference to the future contract to be executed including the allowable timeframe. Number 5. Signatures of the parties. This brings us to the end of this video.